Hi, I'm Todd Smithline, and welcome to Smithline Training. Today we're going to cover one of my favorite topics, video game law. And in particular, we're going to ask the question, are the rules of a video game now copyrightable? First, a quick disclaimer, Smithline Training LLC is not a law firm, and while we'll be talking about legal topics today, we're not providing legal advice. Likewise, no attorney-client privilege relationship is created when you watch one of the programs or attend a roundtable, and as always, if you have particular legal questions, you should consult with an attorney. Now, we follow a two-step training approach at Smithline Training. First, we have you watch the episode as you're doing now, and then we invite you to attend one of our roundtables. And the roundtables are really great because they give you an opportunity to ask questions about the program that you watched and also share best practices with other program participants. We always welcome your feedback, your comments, and even the occasional complaint. Reach out to us at help@smithlinetraining.com. We provide a tool with every episode, and that tool is available right here on the page where you're watching the video, and you might want to download it now and have it in front of you as you watch today's episode. And the tool for today's episode has some of the key copyright law provisions that we'll be discussing and some brief notes about the cases we'll be discussing as well. Okay, so what is today's question? Well, in the last few years, 2 U.S. district courts have found video game mechanics or rules to be protectable by copyright. And a more recent district court started down that same path before reversing itself. So our question for today is, are the rules of a video game now protectable by copyright? How are we going to explore this question? Well, first we're going to ask, what are the rules of a video game? Then we'll take a historic look at how courts have dealt with this question of whether the rules or mechanics of a game should be protectable by copyright. And then we're going to look at a series of cases. The first set of cases come from the arcade era. The next set of cases come from mobile game clone cases. So more recent cases where publishers have released mobile games that look just a little bit too similar to other games and have been sued. And in particular, we'll look at 2 cases, Tetris and Spry Fox. We're then going to look at the DaVinci case. Now, DaVinci deals with board games, but the court followed the reasoning of these video game cases. So those are the cases we'll be looking at today. After the cases, we'll ask if copyright is not the right way to protect the rules of a game, is there some other way to protect game rules? And then we'll ask if game rules are being afforded greater protection under copyright now, why might that be? And finally, as always, we'll end with some questions from the roundtable. Okay, so let's get going. Let's get going with this question of whether or not copyright protects the rules of a video game. And as I said, we're going to start first by asking, what are the rules of a video game? And truth be told, before we can even answer the question, what are the rules of a video game, we probably need to ask, what are the rules of a game in general, or particularly the rules of a board game? So here you see a set of rules from a game called Legends of the Three Kingdoms. Now that game comes up in a case we'll be discussing, the DaVinci case. But for a board or a card game, it's pretty straightforward what the rules are. You open the box and you pull them out and they're printed for you. And so the rules of a board game are instructions that explain how to play the game. But the rules can also manifest themselves in other ways. They can manifest themselves through the pieces on the board itself, cards that you may draw that give you special powers or special points. So when we think about the rules of a board game, we should think about both the set of instructions that teach you how to play, but also the game itself, what's written on the board, the pieces, the tools, and the cards. But collectively, those are really the rules of a board game. So if those are the rules of a board game, what are the rules of a video game? Well, for a video game, the rules are often the mechanics or the gameplay of the game itself. We know that when we start up a video game, we're not typically presented with a whole lot of text to read. There may be, in a modern video game, some drop-downs or tutorials to tell you how to play the game. But essentially, you learn to play a video game by playing the game. So let's take an example. Here's Donkey Kong. Now, if we're playing Donkey Kong, we know that we're playing the role of Jumpman or Mario. And our objective is to rescue this damsel in distress. And to do that, we must overcome obstacles placed in our way by Donkey Kong. We're going to have to avoid barrels that are being rolled at us, and we're going to have to make sure that we get and clear these levels before we run out of lives. We can earn more lives as we go throughout the game, but at the end of the day, the rules of Donkey Kong are expressed through the mechanics or the action of playing the game. So the rules of a video game are often functional rules which dictate how you can move a character, how points are scored, and how you win or lose. That is what I would suggest are the rules of a video game. Here's another way to look at the rules of a video game. If you're playing Halo, Master Chief can survive a free fall from space, but he can't swim. Okay, so is there any theory, you might be asking, that can help us understand how to think about the rules or mechanics of a video game? And the answer is yes, there is. Bruce Boyden of Marquette University, of Marquette Law School, has done a lot of thinking of this question of what are the rules of a video game and how should we think about those rules in the context of copyright law. And he says that the rules of a game establish the game space or the magic circle, but they do not tell the player what to do inside it. Indeed, exploring that space by making moves in the game is what it means to play the game. He goes on to say that games are systems and that systems are shells into which users pour meaning. While they may contain expression themselves, that expression is there merely to facilitate the meaning added by the user. So what he's saying here is that rules establish the game space, the limits and affordances of the game, but they don't provide the content or the meaning of the game. A game is a system, and it's the users playing the game that provide the meaning for the game. Okay. So how have courts historically looked at this question of protecting the rules of a game? Let's look at some of the earliest cases in which courts had to answer this question. Do we protect the rules of a game? And I would suggest that historically the rules of a game were not protected by copyright. Let's go to 1929. This is a book, a compendium of rules of how to play bridge. It was published by Foster. So what Foster did is he went around to various bridge clubs and he took their methods of playing bridge and in his own language expressed those rules in a book. One of the clubs, the Whist Club, sued Foster claiming copyright infringement. They claimed that Foster did not have the right to include the rules for Whist Club bridge in his book without their permission. And then we get this decision, and this decision is really a model of efficiency. The entire decision is 3 sentences, and I have 2 of them for you here. 1929, Southern District of New York, the court tells us as follows. The court says, in the conventional laws or rules of a game, as distinguished from the forms or modes of expression in which they may be stated, there can be no literary property susceptible of copyright. The defendant has not infringed because he has not copied the literary composition of the plaintiff's publication, but in language quite distinctly his own, has restated the same set of conventional precepts. So the court says you are free to copy the information, the rules about how to play Whist Club bridge, as long as you don't steal the actual expression that the Whist Club used in describing those rules. So what does the Copyright Office have to say about this question of the protection of the rules of a game? Well, we have a circular from the Copyright Office from 2011. Now, the Copyright Office circulars are not binding precedent, but they do reflect how the Copyright Office, at least at that moment, is thinking about an issue. And we do find these circulars cited in cases, and they can be influential on how courts rule. So what does the Copyright Office tell us? The Copyright Office says that copyright does not protect the idea for a game, its name or title, or the method or methods for playing it. Once a game has been made public, nothing in the copyright law prevents others from developing another game based on similar principles. And then finally, it's always helpful to go all the way back to the ultimate source, the US Copyright Code. The Copyright Code tells us that copyright subsists in original works of authorship fixed in any tangible medium of expression, but excludes any ideas, procedures, process, system, method of operation, concept, principle, or discovery. That's 17 U.S.C. 102A and B. So again, copyright protects expression of ideas, but not the ideas themselves, nor functional processes or systems. So before we look at the cases that are going to try to draw this line between protecting game rules and protecting game expression, it's helpful to refresh ourselves on how copyright infringement analysis generally works. Now, I've simplified this a bit, but most copyright cases are going to come down to these following core principles. When comparing two games for infringement purposes, what do? Well, first, we filter out the elements that are not protected by copyright. What do we filter out? We filter out the ideas of the game. We filter out what we call scène faire. These are stock or cliche expressions which necessarily follow from the idea of the game. This is sometimes also referred to as things which must be done. We also filter out, or we should anyways, I would contend, the rules of the game. And sometimes we think of taking the rules of the game out because the rules reflect the idea of the game. And other times, courts will say the rules of a game should not be protected because the rules really reflect a system or a method of operation, which, as we just learned, is not protectable by copyright. But whether we take the rules of a game out because we think of them as ideas or because we think of them as unprotectable processes or methods, we should remove the rules of a game before we proceed to compare the expressions of the game to see if we have copyright infringement. And of course, that's what we do next. So after we remove ideas, scène faire, and the rules of a game, we compare what's left to see if what's left is substantially similar. And I just want to note also that courts tend to give thin copyright protection for more factual or prosaic expression and stronger protection for more fanciful or unique expression. Now, this is judge-made law. You're not going to find thin or strong copyright in the copyright code itself, but the courts really do look at things this way. The more fanciful, the more expressive, the more unique your ideas, typically the stronger copyright protection you're going to get. Okay, so now that we know how courts deal with copyright infringement and how they look at this issue of the rules of a game, let's look at these principles as they're actually applied in cases. And our first set of cases come from the arcade era. So our first case is Atari versus Amusement World. This is a district court case from Maryland in 1982, and this involves the game Asteroids. Now, Atari released Asteroids in 1979, and it quickly became one of the biggest selling video games of its era. And if you're not familiar with the game of Asteroids, you're in a spaceship floating in a field of asteroids, and your objective is to shoot down these asteroids. And as you shoot the asteroids, they gradually become smaller and smaller and clear these fields of asteroids before you either get hit by the asteroids yourself or you're hit by various antagonist spaceships that fly along and try to shoot at you. That's the basic gameplay of the game of Asteroids. And it's interesting to note this is one of our first arcade games. It's one of our first hits. And many of the early arcade games were based on space themes. It was very popular when these games first started coming out to set your game in outer space. So that's exactly what a company called Amusement World decided to do. Now, Amusement World was a small shop. They were basically in the business of servicing arcade games. But in 1981, they released their own game, and they called it Meteors. And Atari took quick notice of this game and thought that Meteors was just a little bit too close to Asteroids, and therefore they brought suit for copyright infringement. So what does the court do with this case? Well, the court says that between the two games, the principle of the game and at least 22 of the design features between Meteors and Asteroids were either the same or identical. But the court did notice some differences. They found 9 differences between the games. And those differences included the fact that Meteors was in color and was more realistic than Asteroids. The fact that in Meteors, your spaceship starts on the ground and takes off, whereas in Asteroids, you begin in the asteroid field in space. Meteors plays faster than Asteroids. And finally, in Meteors, you can fire continuously. Don't forget, we're playing in an arcade cabinet at this time, whereas in Asteroids, if you wanted to fire quickly, you had to keep hitting the panel to hit the fire button. So those are the court differences that the court finds. So what does the court do with this? Well, interestingly, the court says that Meteors does not infringe Asteroids. Well, why doesn't it infringe? The court said those similarities that they identified were inevitable given the requirements of the idea of a game involving a spaceship combating space rocks, and given the technical demands of the medium of a video game. Let's unpack that for a second. What the court's saying is, if you want to make a game that is about this topic of a spaceship combating space rocks, there are a number of things you're inevitably going to have in your game to have a game on that theme. And so therefore, we're going to allow Meteors to have those similarities to Asteroids because they're necessary in order to produce a game on a similar theme. And then the court also says a footnote here that some of these similarities might have been due to the technical demands of the medium of a video game. And this is an issue which comes up not infrequently in video game cases where the court says there may be limitations, technical limitations on what you're able to do within the screen or within the processor or within that game. And so we want to take that into consideration as well when we're considering whether what you're doing, the copying you're doing, or the things that you're doing are similar should constitute copyright infringement. But the key thing here was the court's willingness to say we can identify this theme of a spaceship combating space rocks, and we're going to allow other games which do similar things. The court ends by saying, to put it bluntly, defendants took plaintiff's idea. However, copyright laws do not prohibit this. Our next case involves Pac-Man. This is Atari versus North American Philips. It's a Seventh Circuit decision, and it's from 1982. Pac-Man is an arcade game released by Japanese publisher Namco in 1980. And as you well probably know, it became, and still is, one of the most popular and successful video games of all time. Well, Namco licensed Atari the exclusive right, to distribute Pac-Man in a home video game for the US market. So you see here on top the arcade version of Pac-Man, and below the version of Pac-Man that Atari ultimately released for its home video game system, the 2600. Now, Atari did not really bathe themselves in glory with this release, but Pac-Man was so popular that even a version of Pac-Man that looked like what you're seeing on the screen was a huge hit for Atari and one of the biggest hits for its 2600 console system. But Philips, which had its own home console game called the Magnavox Odyssey, also wanted to have a Pac-Man-like game in the market. So they decided to release their own game called Casey Munchkin. They initially looked into getting a license for Pac-Man itself, found out that they weren't going to be able to do that, and decided to just create and release their own game called Casey Munchkin. And you can see Casey Munchkin here on the right. So Atari sues North American Philips for copyright infringement based on Casey Munchkin. So what does the court do with this case? Well, the court says there are a number of similarities between Pac-Man and Casey Munchkin that we're going to allow. And we're going to allow these similarities because the things that Casey Munchkin has copied from Pac-Man are standard game devices. So what are they? They say the maze design is something that we're going to allow Casey Munchkin to copy. The scoring table is something we're going to allow Casey Munchkin to copy. The dots. So as you know, if you've played this game, you eat these dots, and if you eat the larger dots, they cause the ghost monsters who've been pursuing you to reverse from having been predator to now being your prey. And we'll talk about that role reversal in a second. But the court says the concept of eating the dots itself, we're going to allow Casey Munchkin to copy that. And finally, the court says the tunnel exits, which are the ability to exit one side of the screen and enter on the other, are nothing more than the commonly used wraparound concept adapted to a maze chase game. So here we have the court in the very early era of video games willing to say that a concept like a tunnel exit was commonly used and something we were going to allow other games to copy as well. So these are all things the court said that Casey Munchkin could copy. But the court did find infringement. And where did it find infringement? It found infringement in the Gobbler and Ghost Monster characters. So there's your Pac-Man Gobbler, there's your Casey Munchkin Gobbler, and as you can see as well, in both games we have the Ghost Monsters. The court found that Casey Munchkin's gobbler was virtually identical to Pac-Man. The shape of the body, the V-shaped mouth, the distinctive gobbling action and sounds, and role reversal and regeneration. So what happens in Pac-Man is that if you eat one of the larger dots, you cause these ghost monsters who've been pursuing you to become your prey for a brief period of time. They start blinking, they start running away from you, and if you are able to get to them before they turn back, you get additional points. So that gameplay, if you will, or that character of the ghost monster, the court said that's protectable by copyright as well as the gobbler. So again, both the gobbler and these ghost monsters were protectable by copyright, and the court says that they, in the case of the gobbler, that is virtually identical, and as you see here in the case of the ghost monsters, that they appear similar in shape and movement to their Pac-Man counterparts. So in summary on this case, the maze design, the scoring table, the dots, the tunnel exits, these are all sine faire, that's the phrase the court used, and they're protected against only virtually identical copying. But the gobbler and the ghost monsters, these constitute distinct characters that are fully protected by copyright. So here we see the court doing this work of saying these mechanics, these elements of gameplay, these things that we're going to call sine faire, that can be copied, but the characters of the game itself, we're going to protect that as expression, and we're not going to let Casey Munchkin use those characters. And now we come to part 4, Attack of the Mobile Clones, Tetris and Spry Fox. In 2 recent cases involving mobile game clones, courts extended protection of mechanics that look a lot like game rules. So now we move from that arcade era to the modern era, and mobile games in particular. So here we have Tetris. This case is Tetris Holding versus Ziko. It's a District Court of New Jersey case from 2012. And as you're probably familiar, Tetris was originally developed in the Soviet Union in the mid-1980s, and it's really become one of the most successful and widely licensed game on every conceivable platform in the history of video games. First, a little quick background on Tetris that's going to be relevant to how we think about the game of Tetris from a copyright perspective. Tetris is a puzzle game that uses shapes called polyominoes. Quite simply, a polyomino is a plane geometric figure formed by joining together one or more equal squares edge to edge. So here you see 4 squares joined. Those are tetronomos. Polyomino puzzles, so puzzles using these shapes, date back to at least the early 1900s. First they were made out of wood, then they were made out of plastic, but people have been playing games with polyominoes and trying to fit them together for quite a long time. In fact, Alexei Pajitnov, who created Tetris, himself has talked about playing a version of a polyomino puzzle game when he was a child back in the Soviet Union. That particular version involved pentominoes, which are 5 squares joined together, rather than tetronomos, which are the pieces used in Tetris. But in any event, he himself played with these games, and that's what inspired him to make the game of Tetris. Now, as I mentioned, Tetris itself uses brightly colored tetronomo pieces, and I think it's interesting to note that the game uses all 7 possible shapes of tetronomos, and here they are. So now back to our case. So a company called Mino comes along and decides they'd like to release a version of a Tetris-like game for the Apple iPhone. Now, this is in 2009. The company that released the game is called Ziko. And at this time, mobile games were really just starting to take off, and a lot of people were rushing into the market. And Ziko got the idea that they would come to market with what was, I think, initially a multiplayer version of Tetris, and they called their game Mino. Now, as you might imagine, Tetris Holding was not very happy with this, so they brought a copyright infringement claim against Mino. That in itself is not that surprising. Here you can see the 2 games side by side. They are very similar, but what's interesting for our purposes is that in bringing that lawsuit, Tetris Holding used really broad functional language to describe what they thought it was about their game that was protected by copyright. So this goes before this district court in New Jersey, and they rule as follows. They rule that sine faire, this concept that was so helpful in the Pac-Man case, and in the Asteroids case, does not apply here. The court says Tetris is a purely fanciful game, meaning it has no grounding in the real world, unlike a video game simulating a karate match or a golf game, and both the karate match and the golf game refer to other video game cases that found Senefaire in those particular real-world contexts. The court goes on to say that Senefaire has little weight in instances such as this because there are no expressive elements, standard, stock, or common to a unique puzzle game that is divorced from any real-world representation. The court says that Ziko, the publisher of Mino, was free to design a puzzle game using pieces of different shapes instead of the same 7 pieces used in Tetris. So the court here is saying that because this puzzle game is not grounded in the real world, that Ziko is not free to make a game that uses the same pieces, or at least not the same 7 pieces used in the game of Tetris, that we're not going to consider that Senefaire. The court then goes on to issue a very broad infringement ruling governing what I would suggest are the mechanics of Tetris. The court rules that none of the following elements are part of the idea or the rules or functionality of the game of Tetris, but rather are a means of expressing those ideas. The court says the design and movement of the playing pieces, including the bright colors, the individually delineated squares within the pieces, and the downward, lateral, and rotating movement of the pieces as they fall, the court says that's protectable by copyright. The court says the 10 by 20 dimensions of the playing field are protectable by copyright. Likewise, the display of garbage lines, which is something which can make the screen harder to clear. The appearance of ghost or shadow pieces. So you can see there that if this blue piece falls in its current orientation, it's going to end up where you see that arrow below, where you see that grayed out space. That's what is meant by a ghost or shadow piece, and the court says that is protected by copyright. The display of the next piece to fall to tell you what's coming next, that's protectable by copyright. The change in the color of the pieces when they lock in at the bottom and you've completed a row. And finally, the appearance of the squares automatically filling in the game at the end of the game. All of those things, the court says, at least taken together on this set of facts, constituted copyright infringement. Now, it's interesting to note that this was a ruling on summary judgment. It was not appealed, and the case ultimately settled. So although this is just district court law, it sits where it is. And while it's not precedential, it has proven to be highly influential in other video game cases. And we'll see that immediately in our next case. So our next case is a case about a clone of a Match 3 game called Triple Town. Here's the game of Triple Town. It's released by a company called Spry Fox, and it's released first on Kindle. There's some interesting facts here. Spry Fox approached a company called LOLApps about the possibility of porting this game, which was originally released on the Kindle, over to Apple's iOS, on which iPads and the iPhones are run. Instead of doing that work for Spry Fox, LOLApps decided to release its own game, its own Match 3 game, and that was called Yeti Town, and they released that on iOS. So Triple Town brought a copyright infringement suit against Yeti Town, and the court then had before these two games, and they had to decide, is what Yeti Town copied from Triple Town, is that copyright infringement? So let's look at these games. Both of these games are variations on what we call a Match 3 game. To put this simply, in Triple Town, if I arrange 3 grasses together, they turn into a bush. And if I arrange 3 bushes together, they will turn into a tree. Likewise, if in the game of Yeti Town, I arrange 3 saplings together, they become a tree. And if I arrange 3 trees together, they become a tent. So that's what a Match 3 game is. You match like objects, and then they move up to the next higher level object. In both games, you also have antagonists who are trying to make your life harder while you do that. So is this copyright infringement? Well, look, we've got different seasons here. Triple Town looks like it's set in the spring, Yeti Town in winter. We have different art. The art is similar in look and feel, but it's definitely different art. And we have mostly different characters or objects, or the things that are the same, I would suggest, are basically generic, like trees. So what does the court do with this? Well, there's a motion to dismiss by the defense, and the court says this claim is going to survive that motion to dismiss, the court says there may be copyright infringement here. And where does the court locate that possible infringement? They say that infringement may be in the object hierarchy or the field of play. They say the object hierarchy between these two games is similar. Here's the object hierarchy in Tripletown. You go from grass to bush to tree to hut. And here it is in Yeti-town. You go from sapling to tree to tent to cabin. And the court says that while grass and sapling are different, and bush and tree and tent, and hunt and cabin, the fact that you follow the same object hierarchy, that could be copyright infringement. And the court says that that object hierarchy, when coupled with what they call the field of play, those two things combine to comprise a setting and a theme that is similar to Tripletown's. So in Tripletown, we have a meadow, and the court says, well, a meadow is really not so different from Yeti-town's snowfield. In Tripletown, we have bears. There are antagonists. And in Yeti-town, there's a Yeti. And the court says, well, both bears and Yetis are wild creatures. And finally, Tripletown is set in a patch, and Yeti-town is set in a plain. And the court says those are plausibly similar. Now, from a copyright law perspective, we often think of a meadow and a snowfield or a bear and a Yeti as very different things. But the court here is saying that this general setting and theme is similar enough that we might have copyright infringement. So the court finds what they say are sufficient objective similarities in protected expression to deny the motion to dismiss. And again, here, there's no appeal and the case is settled. So while it's just a district court case and while it's only on a motion to dismiss, we have this case and it has proven to be persuasive to later courts. So where are we after the Tetris case in Spry Fox? Well, in Tetris, we had Mino that copied pretty much all of the rules of Tetris and arguably most of the expression. At least that's the way the court looked at it. And that was infringement. Then we move on to Spry Fox. That was Tripletown versus Yeti-town. And again, Yeti-town followed almost all the rules of Tripletown. And I would say, at best, most charitably, they copied about half the expression. And the court rules that that's infringement, or at least it sufficiently could be infringement to survive a motion to dismiss. But this then poses a very interesting question, which is what happens if you again copy all the rules but none of the expression? Well, I'm glad you asked because we have a case which answers this question. And this is the DaVinci Case. Now, after Tripletown came this case, DaVinci, which was concerned with copyright and the rules of a game, but this time it was in a board game. The game at issue here is a Wild West-themed card game called Bang. And it's a role-playing hidden identity game released by an Italian publisher, DaVinci, in 2002 in the United States. This game was a really big hit. It won multiple Best of awards and sold quite a number of copies. And after Bang came into the US a game called Legends of the Three Kingdoms. This was released by a Chinese publisher, Yoka, through its US distributor, Ziko. And the interesting thing about Legends of the Three Kingdoms, and if you just look at those covers, you might not think there's that much similar. If you look at the titles, you wouldn't either. But the interesting thing about these two games is that, as I'll explain in a minute, they have the exact same rules and totally different expression. So after Legends of the Three Kingdoms was released in the United States, the publisher of Bang sued for copyright infringement. So what does the court do with this? They have virtually identical rules, and that is the characters, life points, their roles, their win conditions are basically the same between these two games. But they have completely different art, they're in different settings, and I would suggest the expression of the games are totally different. Bang is set in the Wild West period, sort of a spaghetti Western themed games, and Legends of the Three Kingdoms is based on 3rd century China. So here you see Bang. Here's a character card from Bang. This is Calamity Janet. And here you see the corresponding character card from Legends of the Three Kingdoms. As you can see, the art totally different, the character names totally different. So let's dig into that a little bit. In both games, you are dealt a character card and a role card. Now, the character gives you your personality. It gives you the number of life points you have and a special attribute. So let's look at that. Here's a character card from Bang. This is Calamity Janet. She has 4 life points, and she has a special attribute, which is that she is able to use a Bang card, which is what you use to fire a gun, and a missed card, which is what you use to avoid being hit by a shot, interchangeably. And here's the corresponding card from Legends of the Three Kingdoms. This is Zhao Yun. This character has 4 life points, just like Calamity Janet, and this character also has the ability to play their strike card and their miss card, or the corresponding cards and legends, interchangeably. So I said you get a character card and you also get a role card. Now each role has a specific win condition. The roles in Bang, for example, are Sheriff, Deputy, Outlaw, or Renegade. So if you get the Sheriff card, you are told that you're going to win the game if at the end of the game all of the Outlaws and Renegades are dead. And the Monarch card is the corresponding role card in Legends of the Three Kingdoms, and it has the same corresponding win condition. So again, you get a character card and you get a role card, and that becomes the character you play in the game. The games also have functionally similar cards for weapons, missing shots, healing, and extending the range of weapons. So for example, here's a gun from Bang that has a distance of 2 power, and here is a sword from Legends, which also has a distance of 2 power. So the underlying mechanic of how the weapons work is the same across both games. In both games, the ability to reach your target with a weapon is determined by the number of spaces between the players around the table. Let's take an example. Let's assume a weapon that has a strength of 2. So here you are in Bang. If you have a weapon of a strength of 2 and you're player A, you can reach player B or player C with that gun. Likewise, same exact thing in Legends of the Three Kingdoms. If you're player A and you have a sword with 2 strength, you can reach player B or player C. So that core game dynamic of how weapons work is exactly the same. So is this copyright infringement? As I said, we have nearly identical rules, including in how the characters, roles, and weapons work, but we have completely different expression. So what does the court do with this? This is Southern District of Texas, 2014. Well, on the motion to dismiss, the court says there might be copyright infringement here. The court quotes extensively from Tetris and Spry Fox, and the court says the 7 characters from Legends have capabilities and life points that are identical or substantially similar to those of the corresponding 7 characters in Bang. The court said the roles and the interplay of the characters are protectable expression. But then the court reverses itself on summary judgment, and it rules that game rules are not protectable expression. The court says that unlike a book or movie plot, the rules and procedures, including the winning conditions that make up a card game system of play, do not themselves produce the artistic or literary content that is the hallmark of protectable expression. And in doing that, they're quoting to Bruce Boyden, who is the professor I mentioned at the beginning of our program today, who's written on these issues quite extensively from a theoretical point of view. The court goes on to say that unlike Legends of Zelda, the video game, Bang falls into a category of games which have plot progressions and characters who interact in ways that fall short of the expressive character interactions and plot progressions that are protected by copyright law. The court says the effect of a character's special abilities and life points on that player's experience is not helpful to the plaintiff's argument of copyright infringement because copyright does not protect game rules, procedures, or winning conditions that create the environment for the expressive elements of the game. So in the end, the court decides that while Legends of the Three Kingdoms did in fact copy the way you play the game of Bang, the underlying mechanics of the characters and the roles and the weapons, Legends of the Three Kingdoms was allowed to do that because what it was copying was not protected expression, it was just game rules. And a quick postscript on this case, from a bug to a feature, if you look at the marketing copy for this game, Legends of the Three Kingdoms, at least as it appeared when we last checked in December of 2017 on Amazon, you learn that Legends of the Three Kingdoms is a card game based off the Chinese classical novel Romance of the Three Kingdoms and shares many rules with Bang. So here we have Legends of the Three Kingdoms going out to the market and saying, you might really enjoy our game, and by the way, if you know how to play Bang, you know how to play our game as well. So a few conclusions on these cases. As we said in Tetris versus Mino, we saw a case where basically all the rules and most of the expression was copied. In the Tripletown case, all of the rules and maybe about half the expression, but then we had our final question here, what if you copy all the rules and essentially none of the expression, at least if you don't consider capabilities and roles to be expression, and that was found to be not copyright infringement. Some quick conclusions on these cases. First, in both Tetris and Spry Fox, the courts struggled to separate game rules from expression. Each gave broad protection to the underlying mechanics or rules of a video game. In DaVinci, the court initially followed Tetris and Spry Fox, but ultimately reversed itself and refused to protect the rules and character mechanics underlying the game Bang. Now, DaVinci, as I noted, involved board games, not video games, so it's too early to tell whether DaVinci will be a corrective or just a bump on the road to greater protection for game rules in video games. So you might be asking, if copyright is not the right way to protect the rules of a game, is there some other way to protect game rules? Well, how about patents? Here's a patent from 2011 issued to Microsoft. This is a patent on a game achievement system. This patent applies to a system and method for providing game achievements where players are rewarded based on mastering certain in-game facets of play. So this is essentially a patent on receiving digital ribbons and other awards in a game. And like this patent, there are many other issued patents on various aspects of the mechanics of how video games are played. A quick reminder, generally speaking, we use the patent system to protect inventions, or what you might think of as useful information. This is different than copyright, which protects expression. Specifically, patents may be granted to protect a process, machine, or article of manufacture that is new, useful, and non-obvious. Now, an important footnote on patents and game mechanics or rules. In 2014, the U.S. Supreme Court issued a decision in a case called Alice versus CLS Bank, which dealt with a patent directed at what the court decided was really only an abstract idea. The court held that claims in a patent directed at an abstract idea must contain an inventive concept sufficient to transform the claimed abstract idea into a patent-eligible application. In 2016, the Federal Circuit Court of Appeals applied Alice in a case dealing with a patent on a method of playing blackjack. The court disallowed the claims after finding that they only covered the abstract idea of rules for playing a wagering game and used conventional steps of shuffling and dealing a standard deck of cards. So I just want to note that at least since the Supreme Court's decision in Alice, which invalidated a patent on the grounds that it was really just protecting an abstract idea as opposed to an invention, at least since that case and this more recent Henry Smith case, there is some question about whether your patents on game mechanics are going to be enforceable. But certainly I think it's fair to say that at least as between the copyright system, which is set up to protect expression, and the patent system, which is set up to protect inventions, methods, and processes, that patents are probably a better place to look for protection of game mechanics or game rules, if anywhere. So you might be asking yourself, well, if video games are in fact being afforded greater protection under copyright law, why might this be happening? Well, a few thoughts on that. First is that mobile games are relatively cheap to make, but they have a huge potential upside. A big hit mobile game could gross $1 million a day, and there's a global market both for the creation of these games and for the sale of the games. So we've got more games in the market now, they're cheaper to make, and we've got more games and more opportunity to make money, you're simply going to see more copying and therefore more cases. So that may be one reason we're seeing this change. The second reason why courts may be affording greater protection to game rules in these video game cases is that the side-by-side comparisons of the games can often look awfully bad for the defendant. Here's a complaint from 2014, Northern District of California, between Glue Mobile and Hothead Games. Glue Mobile is the publisher of a game called Deer Hunter, which is a target shooting game where you're shooting at animals. And Kill Shot is a game that was released by a company called Hothead, which was very similar to Deer Hunter, but your prey in that case, unfortunately, were not animals, they were people. In any event, Glue Mobile sued Hothead Games for copyright infringement based on Kill Shot. And it's interesting, if you look at these games side by side, and as I mentioned, this is in fact an image from the complaint, the games look very similar. But we do have to ask ourselves, is what's being copied here protectable expression? And likewise, do we need to see the games that came before Deer Hunter? Would that inform how we think about what's truly unique expression in Deer Hunter versus what is either scent-affaire or simply the underlying mechanics of any target shooting game? I think the next thing to consider in this regard when we're trying to answer this question as to whether game rules are receiving greater copyright protection is that it's happening in part of a larger trend towards longer and stronger protection for copyright in general. We started out with a 28-year term, we moved to a 42-year term, a 56, 75, and now we're at, for corporate works, work-for-hire works, a 95-year term of copyright. So if game rules are receiving greater protection, it may be part of this larger trend towards greater protection for copyright in general. Another factor that might be in play here is that in copyright cases, unlike in patent cases, we do not have to establish that what we're seeking to protect was either novel or non-obvious. In the realm of copyright, you simply have to demonstrate that what you created was independently created and possessed a modicum of creativity. So again, if these cases are starting to trend into an area where we're protecting underlying mechanics or methods, copyright law is not really well set up to deal with that. In copyright, we don't ask the question, is the work you're seeking to protect novel or non-obvious? As I said, we simply ask, did you create it yourself, and is there a little bit of creativity there? So again, copyright law is not really well set up, doesn't have the internal mechanisms to deal with assessing whether functional matter should be protected. And that, again, may be a factor in play here as to why courts are struggling to draw the lines in these video game cases. Finally, we know that the courts are actually not always playing the games. In fact, in the Spry-Fox decision, the court went out of its way to note that neither Spry-Fox nor Six Waves or LOLApps suggested that the court should compare Triple Town and Yeti Town by actually playing the games. So if you're not playing the games, and I think more importantly as a judge, if you don't have a history of having played these games, like you would have a history of reading books or watching movies or listening to music, when you come to a copyright infringement case, you simply don't understand that what you're looking at might in fact reflect tropes, scent-affaire, ideas that have been well established in video games for a long time. Now, a final thought here. None of this is really new. Odyssey Tennis, released in 1972, came out before Atari Pong, but Atari Pong turned out to be the first gigantic hit of the video game world. And the developers of Atari Pong later admitted that, yes, in fact, they had seen Odyssey Tennis before they released their game. Copying is part of video game history. Games are built on top of other games. In today's world, they're literally modifications, oftentimes, of prior games. So copying in video games is nothing new. And I think that, therefore, poses a special obligation on courts today that are trying to sort out this line between underlying mechanics and protectable expression to really give a lot of thought and understand and try to understand what's expressive here that we should protect, but what's really just an underlying idea or mechanic that we should allow others to copy. So now we have a few questions from our roundtable on this episode. And the first person asks, in deciding game rule cases, do courts ever look to sports? Well, the answer is yes. In fact, in that DaVinci opinion, the court said that the game of basketball, for example, is not protected by copyright. They said basketball has a loosely prescribed progression. Teams trade offensive possessions over 4 quarters of play. Players have assigned roles, such as guard, forward, or center, and in those roles, they interact with each other. But the court says, unlike movies, plays, television programs, or operas, basketball games are competitive and have no underlying scripts. So yes, courts have looked at sports, and they have found that to be a useful analogy in trying to understand what's a rule and what's expression. The next question asks, do you have any tips for developers seeking to avoid infringement claims? Well, yes, we do. First, create your own characters and worlds. The more creative you can be, the more likely you are to avoid copyright infringement claims. Secondly, if you do want to borrow an idea or a mechanic from another game, implement it in your own way. Don't have that mechanic operate exactly like it does in the other game. Give it your own special twist. Third, don't try to leverage others' brand names or trade dress. Now, we didn't talk about trademark in today's discussion, but understand that you want to stay as far away as you can from words, titles, character names, things that are unique and readily identifiable to other games. That will get you into trouble right quick. And even if it turns out that it's not precisely a copyright question, courts in those copyright cases tend to look at that as well, and it can sometimes be harmful to you as a defendant. And make yours look different. Do your own work on the creative end so that your game does not look exactly like the game whose mechanic that you want to emulate. And hand in hand with that, try and make up as many of the rules or mechanics of your own as you can. Our next participant asked, what about copying the world of a game as opposed to its rules? Well, this issue of protecting fictional worlds arises in user-generated game levels and in fan fiction. And it often implicates a relatively tricky question under copyright law. And that's whether copyright law protects individually unprotectable elements of a work when those elements are grouped together in such a way as to create a unique fictional world. Now, a little context here. The Supreme Court has told us in the Feist case, this was a case dealing with copying of listings from a telephone book, that while copying underlying facts like names, phone numbers, and addresses does not constitute copyright infringement, if you copy the selection, coordination, and arrangement of those facts, that might be copyright infringement if that selection, coordination, and arrangement was sufficiently expressive. So with that context, let's take a look at two cases which deal with the question of protecting fictional worlds. The first is MicroStar v. FormGen. This is a Ninth Circuit case from 1998. And the second is a more recent case, Paramount Pictures versus Axanar Productions, Central District of California from 2016 and 17. So as I said, our first case involves the game Duke Nukem. And Duke Nukem was an interesting game because it shipped along with a build editor that allowed users of the game to create their own levels for the game. And a company called MicroStar came along, and they collected up a bunch of these user-generated, user-created levels for Duke Nukem, put them on a CD, and tried to sell the CD. So FormGen, the publisher of Duke Nukem, sued MicroStar, alleging that the CD full of these user-generated levels infringed FormGen's copyright. The CD didn't actually contain the levels themselves. The CD contained what we call map files, which told the Duke Nukem game how to create and display those levels. But in any event, FormGen sued for copyright infringement. And the Ninth Circuit held as follows. They held that the work that MicroStar infringed was the Duke Nukem story itself. And that story was about a beefy commando type named Duke who wandered around post-apocalyptic Los Angeles, shooting pig cops with a gun, lobbing hand grenades, searching for medkits and steroids, using a jetpack to leap over obstacles, blowing up gas tanks, and trying to avoid radioactive slime. The court said a copyright owner holds the right to create sequels, and the stories told in the files that MicroStar was shipping, those user-created levels, were surely sequels, telling a new, although somewhat repetitive tale of Duke's fabulous adventures. A book about Duke Nukem would infringe for the same reason, even if it contained no pictures. So here we have a case saying that user-generated levels may infringe the copyright of the publisher if those levels copy too much of the story or the world of the game itself. Our second case is Paramount v. Axanar, and this involved a fan fiction movie that was to be set in the Star Trek universe. This is from the Central District of California from 2016 and 2017. And what happened here is that Axanar, the defendant, sought to release a feature film set 21 years before the first Captain Kirk episode of the original CBS Star Trek television series. Now, this movie was going to tell the story of a character called Garth of Izar during the war between the Federation and the Klingon Empire. And this character, Garth, had appeared in one episode of the TV series and had been featured in the 2003 novel copyrighted by Paramount. The character Garth was known for leading the Starfleet in the Battle of Axanar. So Axanar is sued by the copyright holders in the Star Trek worlds for copyright infringement. So what does the court do with this? Well, the court has to analyze the Axanar work to see if the elements of the Star Trek universe that Axanar incorporated constituted sine faire or unprotectable elements. So in other words, the court had to look at what Axanar wanted to use from the Star Trek universe and decide whether Axanar was free to copy those things or whether copying those things would constitute infringement. And the elements the court looked at included costumes, geometric shapes, including the Starfleet command insignia. They looked at words and short phrases like the names of the planets or the fictional races involved in the Star Trek world. They tried to sort out elements to see if they were derived from nature, the public domain, or third-party works, including the Vulcan's appearance with pointy ears or the concept of warp drive, the Klingon language, the mood and theme of a science fiction action adventure, and other things which might be sine faire elements, or staples of science fiction such as starships and medals on the uniforms. Finally, they also looked at the specific characters being used in the Axanar production, including Garth of Izar, Soval, and Robal. So what does the court decide here? Well, the court decides that Axanar copied the Star Trek world. The court said that when viewed in a vacuum, each of the elements copied may not be individually protectable by copyright, but the court says even if each of those individual elements were not protected by copyright, unprotectable elements may gain some protection in combination with each other. The court says the defendants copied each of these elements and combined them together in such a way that recreates the Star Trek world. So, did copying the Star Trek world, as the court found here, constitute substantial similarity? Well, this case initially survived a motion to dismiss, and then in 2017, there were cross motions for summary judgment. And here's what the court found. The court found that Garth of Izar, the Klingons and the Vulcans, constituted characters which were protectable expression under a Ninth Circuit case called DC Comics, which involved replicas of the Batmobile. The court went on to say that costumes, settings, and the mood and theme of the Star Trek works as a military space drama, at least when those things were combined together, constituted protectable expression. And the court found that the defendant's work was objectively similar, or objectively substantially similar, and here the court was using the extrinsic test, so the test to be applied by the court as opposed to a jury, and noted that the defendants had achieved their goal of creating an authentic Star Trek film and script. Now, the issue of subjective substantial similarity, or what we call the intrinsic test, was then going to be sent to the jury, but before that could happen, the case settled. So this is where this decision stands as of now. So, yes, fictional worlds can be protected. We saw that in the Duke Nukem case. We also saw that in this more recent Paramount Axanar case. Even if game rules are being overprotected, what's the downside? Well, this is always the quintessential question in copyright law as to how do we identify the problem with overprotection of copyright? And the answer is we just don't know. That's why you're looking at a blank screen. We don't know about the other games that would have been created, the new worlds and experiences we might have been able to enjoy playing in based on concerns about copyright. So at the end of the day, the cost of overprotection are the games we didn't get to play. Hard to quantify, but I think it's real, and I think it's therefore incumbent upon courts to make sure that they are not overprotecting underlying mechanics or rules of a game in these cases. Well, I see the lights, and that must mean we've reached the end of this episode. I want to thank you very much for joining us. I want to invite you to attend one of our roundtables, and I hope to see you at one of them soon. Thanks.